to the power of one. Today, we are going to have a very intense conversation with Kevin Raphael. And Kevin is a defense attorney, and we're going to break down homicide by law. Welcome to the show, Kevin.
Well, thank you, Melly. It's a pleasure to be here.
Kevin, I was watching this documentary. I love watching documentaries. And in this documentary, I heard the detectives say we wanted a murder, not just a homicide. And that confused me so much because I thought a murder was a homicide was a murder. Is there a difference between the two?
There is. Homicide is really the death, causing the death of a human being. Homicide. Murder means that you had the particular mens rea or mental state to intentionally kill someone. That's murder. And there's various degrees of murder with various states of mens rea, which we can talk about in a little bit.
Okay. So, of course, for any parent who has lost a child to gun violence, to any type of violence, or any family member who has lost a loved one, I often hear they want whoever the offender is to be charged with first degree. So I don't know the law. Let's break down first degree, second degree, and third degree murder.
All right. So first degree murder under Pennsylvania law, because every state's law is different slightly. Under Pennsylvania law, first degree murder is the intentional killing. And the statute gives examples: killing by poisoning, lying in wait to kill someone, like an ambush, or any other willful, deliberate, and premeditated killing. So that's first degree murder. And it focuses on the person's state of mind when they killed another person. Second degree murder is also known as felony murder. It's when someone dies in the commission of a felony. So if I was committing a burglary, surprise someone in their home, and then my conspirator shot and killed that person, I'd be responsible for second degree murder or felony murder. And then third degree murder in Pennsylvania is all other types of murder, meaning that there's an intentional killing, but it wasn't premeditated, it wasn't willful or deliberate, it wasn't committed in the commission of a felony. So those are your 3 degrees of murder in Pennsylvania.
Okay, so does manslaughter fall under that? Because you have manslaughter involuntarily and voluntarily, right?
Yeah, so manslaughter is a lesser offense than murder because the mens rea of the doer is different. So voluntary manslaughter, there's 2 ways that you can think about it. One is that it's when you kill someone, when you as the doer have been set upon by a sudden and intense passion, and that leads you to kill the person or someone else by accident because you intended to kill the person that caused that passion. The classic law school example is you walk home into your apartment and your wife's sleeping with another guy, and you killed your wife or that other guy. That's presumed to have been during the sudden fit of passion of finding out you've been cheated upon. So that's voluntary manslaughter. Involuntary manslaughter is different. Involuntary manslaughter is when you kill someone when you're doing something legally or illegally in a reckless or negligent manner. So the classic lawsuit example there is I have a gun. I don't intend to kill any particular person, but I fire a gun into a crowd. Or if you're in Philadelphia on New Year's Eve, you shoot the gun in the air, bullet goes up, comes down and hits someone and kills them. I didn't intend to kill any particular person, but I acted in a way that was reckless or grossly negligent, which led to someone's death. I would be charged with involuntary manslaughter. So so it really focuses on what did the doer intend? What was that person's state of mind
at the time? Now, I don't know if you know about that horrible incident that happened in the subway where it was 2 gentlemen who were tussling and fighting over, I guess, what seemed to be a lighter. And the one young man hits or pushes the other young man, and he falls onto the train tracks. But as soon as he falls onto those train tracks, Kevin, a train comes and rode over him, and unfortunately, he lost his life. So is that the perfect example of probably manslaughter? Because it doesn't seem like, well, we don't know. You know what I mean? So does the evidence in that kind of situation, could it go either way?
Well, any of these decisions about whether you're going to the prosecutors are going to charge someone or whether the person will be found guilty if they ultimately went to trial is going to be really fact based. And a lot of those facts are trying to divine what the person was thinking when they
Mm,
acted in a way that caused the death. So in that
mhm,
example, if the facts were if the facts were demonstrated the way you've explained them, then that person would most likely be charged with or found guilty of uh, either involuntary manslaughter, or if you're going to argue that they were in the passion that was induced because they were fighting over the lighter, voluntary manslaughter. But I don't think
mm,
that would rise to the level, given the facts you've described, of murder of any degree, first, second, or third.
mm, mm. Okay. And some people again probably don't understand that fact because all they know, the end result is that their family member is dead, and they don't understand the law. You know what I mean? Of it. And we get that because people's hearts are broken. How is it that, and again, so we're going to go back to the first, second degree, third degree, and manslaughter, those sentence times. I know sometimes some people are so heartbroken, people may take a plea deal, but how can someone lose a life and that offender do like 5 years in prison? Is there, like, under the law, explain that piece as far as like how much time is given to someone who has taken someone's life?
Certainly. Well, I'll start with the cold legal analysis. And I think I actually have a little personal anecdote I could share that I think fits that perfectly. So in Pennsylvania, the statutes for different offenses lay out the maximum sentence. Doesn't mean that the courts would impose that sentence, just what the law says is the maximum sentence. So first degree murder, it's life or death penalty in Pennsylvania. We have the death penalty. I isn't used that often anymore, but the maximum penalty for a first degree murder is either a life imprisonment or the death penalty. Second degree is life. Third degree, it's a maximum of 40 years imprisonment. Voluntary manslaughter, it's 20 years imprisonment.
Mhm.
Involuntary manslaughter, it's 5 years. Or as a misdemeanor of the first degree, there is a from a legal analysis, there could be a involuntary manslaughter, which is a felony of the second degree. I'm sorry, the third degree, if I am responsible for taking care of a minor and that minor dies in my care and it's an involuntary manslaughter, that would be considered a felony. That would be a 7 year maximum. So those are the statutory maximums. I can understand how people who have loved ones killed can be torn or angry at the system if there's a plea down or if the sentence doesn't seem to match the loss of that person's life. Unfortunately, my older brother was killed in 2004 by a person who was high in marijuana, driving a plumber's truck. And that person hit my brother's car in a T-bone fashion, killed him instantly. Uh,
Mm,
Unfortunately, it took place on the New York Connecticut line, and the state troopers asked the paramedics to draw the person's blood because the cops suspected that he was high in marijuana and he was going to be taken to a hospital in Connecticut. Unfortunately, in New York, it's illegal for a paramedic to draw blood like that. So the blood and the results of that fact that he was hot, the doer was high in marijuana would have been suppressed. So the
mm,
DA pled the case down to involuntary manslaughter instead of vehicular homicide, which is
mhm,
another crime that would have afforded a higher sentence. And I was left to explain to my 15-year-old nephew and my 10-year-old niece how the person who killed their father was going to get probation, which is what the deal
mm,
was. So just because the crimes have statutory maximums doesn't mean that's what their circumstances will result in. That may not be what the judge decides to impose, and it may not be what the prosecutor offers in a plea deal because circumstances are such that the prosecutor doesn't think they can prove the highest level offense, or there's some defect in the evidence, like in my brother's case. So they're concerned that they'd rather get a plea and get the person supervised, even on probation, than to let the person walk. So those are kind of decisions that prosecutors, and I was a prosecutor for 7 years in Philadelphia, those kind of decisions prosecutors have to make based on the evidence. And it's hard for the family to understand that. And those are difficult conversations to have with the family. Having both given them and received that conversation, I can understand that. But that's why if your loved one has been killed, you may not be happy with the result. You may not think that the sentence imposed is sufficient to punish the person for taking your loved one's life, but those are the circumstances.
Does priors play a part in the sentencing phase, or is that not a part? So say if, I'm not going to say me because I don't want to put that in the atmosphere, somebody commits a crime,
right,
and they're apprehended for that crime, and they have priors. Can that come up in this new case?
Yes, but except in very limited circumstances, very few that would apply here. Mm-hmm. The prior criminal conviction, the record of convictions, not arrest, but convictions, is something that comes up at the sentencing phase after the plea or after the determination of guilt. Because in our system, the law doesn't allow the prior convictions, except in limited circumstances, to be known by the fact finder, judge, or jury during the decision of guilt or innocence, because it may improperly impact the decision, right? You wouldn't, the finder of fact wouldn't be making the decision based on the actual facts, but on the fact that the person had previously been convicted of a crime. But at the sentencing phase, prior record does matter. Prior convictions do matter because the sentencing recommendation in Pennsylvania is based on a grid, with the x-axis being prior record score. The more convictions you have, the higher that score, and the y-axis being the offense level. And each crime is assigned an offense level. In these circumstances, murder one would have the highest offense level, involuntary manslaughter would have the lowest offense level of the crimes we're discussing. And then you move along that grid, and that would give a recommended sentence range that the judge could impose. It's not mandatory in Pennsylvania. So yes, the prior record of convictions will play into the sentencing decision.
Kevin, you've been a part of Northwest Victim Services for a while. You are a board member, and you've always been an amazing, amazing board member. And knowing Philly and working for the Philadelphia District Attorney's Office, you've seen how crime and shootings have changed in the city of Philadelphia. At what age, what young age, can a child be charged for a homicide or a murder? So we'll go at that age. And if they're below that age and they happen to take someone's life, what happens?
All right. So in Pennsylvania, and this again differs by state, in Pennsylvania, if a person is charged with murder, no matter how young they are, they're treated as an adult. Now, the defense attorney can file a motion to request that that individual be treated as a juvenile in the juvenile system, but that's rare in a charge of a murder. Otherwise, for example, in voluntary manslaughter and involuntary manslaughter, a person would be presumed to be charged as a minor. However, the prosecutor can make a motion to have the minor treated as an adult. And there, that person's prior record of juvenile delinquencies or convictions would come into play and help in the court make that decision about whether that child would be treated as an adult. But if someone's charged with murder, any of the 3 degrees, they're going to be treated as an adult from the outset.
Could someone 9 or 10 years old be charged with murder?
They could be, but I think that would be an exceptional case. There have been cases in the past that I'm aware of in other parts of the country where younger people of that age have committed a blatant murder and clearly intended to do so. But there is a certain age, and I don't remember what it is in Pennsylvania, below which you're not considered to be competent
Mm.
or to be charged with a crime. In certain, it could be five. I think it might be 5 or 8. But the law presumes that if you're below that age, that you don't know enough to make a decision
Mm.
to know whether you're actually committing a crime or doing something wrong. You're not considered to be competent to reach the mens rea required to be charged with a crime.
Kevin, I've seen a lot over the last 9.5 years in working for Northwest Victim Services and for the Philadelphia District Attorney's Office, helping families who unfortunately have had homicides in their family. There are times when justifiable homicides occurred and no
Yes.
time has been, or no time will be served to the person who had the justifiable homicide. So let's speak about justifiable homicides.
All right. So again, we'll talk about the law in Pennsylvania because it's going to differ depending on the state. There's two typical justifiable homicides. There is self-defense and defense of others. Um, and without getting, and this can get complicated. Again, it's going to be very factually driven, right? And because you can never really get inside a person's head, the facts are going to determine whether or not the person meets the elements of a justifiable homicide defense. But typically, a person has to believe that the use of force is immediately necessary to prevent that person or someone else from being a victim of unlawful force by another person. So if I'm the person who commits the justifiable homicide, I would not be charged, or I could be acquitted of a murder if it was determined that at the time I reasonably believed that I needed to use deadly force to prevent the person that I killed from either killing me or seriously hurting me or hurting someone else. And the offenses that you can defend yourself from are being killed, having serious bodily injury inflicted upon you, some sort of sexual assault or intercourse, or if you were in your own home and someone burglarizes your home, it's presumed that you have a reasonable belief that you are using force to protect yourself. Because the law presumes that if someone's in your home and you're there, they're there to inflict serious bodily injury or some other violence upon you, for which you can use force to defend yourself. So those are the circumstances in which homicide could be justified. You're protecting yourself or you're protecting others. Now, in Pennsylvania, if you're on the street, not in your home, but if you're on the street and someone approaches you, you do have the obligation, if you could reasonably believe that you can retreat without being hurt, then you have the obligation to retreat safely. Now, if you don't feel, and it's reasonable for you to believe that you can't retreat safely, then you can use deadly force. But otherwise, if the circumstances suggest that you could have fled or retreated, you have that obligation, and you're going to lose the right to an absolute self-defense or justifiable homicide. Now, in that circumstance, then you could be charged with involuntary homicide. I'm sorry, voluntary manslaughter, which is that you thought that you're a reasonable belief that you could use self-defense, but that belief ultimately was not reasonable. So therefore, you're not acquitted, but instead of murder, you would be charged with voluntary manslaughter. So that's, in a nutshell, justifiable homicide in the Commonwealth.
Does that go on the person's record who has the justifiable homicide? Like, if you're going to a job and they need to check your background, is that listed or it's nowhere?
If you are arrested for a crime or for, let's say, murder, but it turns out that that murder was justified by defense of yourself or others, then you would either be acquitted by a fact finder or jury, or the prosecution would drop the case, in which
Mm,
case there would be no conviction and you could have that arrest expunged.
mm, okay. Okay.
Okay. But you would have to have the arrest expunged, otherwise it would show on your record as an arrest.
Okay. Okay. So, Kevin, you are a defense attorney. What made you want to become? I know you worked at the Philadelphia District Attorney's Office for a little while, a long while. What made you want to become a defense attorney? Was it something personal, or was it something that you saw, or someone that you knew went through something, and you said, "I want to fight for those on the other side"?
So I was a rare prosecutor in that in my wallet, I had both a District Attorneys Association card and a ACLU card. From a very young age, I strongly believed that the Constitution of the United States affords everyone uh, numerous constitutional rights in criminal cases, because the power of the government has to be uh, minimized as much as possible and only used in appropriate circumstances. So when I was a prosecutor, I zealously prosecuted, although a prosecutor's rules of professional ethics, the first rule is to make sure that justice is done. So as a prosecutor, I would look at a case, and I was in the office for 7 years, and I primarily, in my later years, prosecuted sexual assaults against children, but I would use my prosecutorial discretion to make a determination about whether justice is being done or not. That's what drove charging decisions. That's what drove whether I was going to plea or go to trial. As a defense attorney, a defense attorney's primary obligation in a criminal case is to zealously advocate for their client. And in the context of a criminal case in the United States, that's meaning standing between the power of the government, state or federal, who's trying to prosecute your client, and make sure that the government meets its obligations and its burdens. So if your client is found guilty, you put the government to the test, and that they met their obligations to gather acceptable evidence, to present acceptable evidence in a way that proved beyond a reasonable doubt your client committed the crime of which they were charged. And that's what makes our criminal system and under our Constitution as powerful as it is, and is different than so many other places in the world. So when I was sworn in to take the bar, I took an oath to uphold and defend the Constitution, as does every other lawyer who's sworn in as a member of the bar. As a criminal defense attorney, upholding the Constitution means making sure the government meets its burden to prove a case beyond a reasonable doubt, and to use everything in my power lawfully and ethically to hold the government to its burden. And when a defense attorney does that and the prosecutor does their job right, you have the greatest sense that justice is being done.
I've never heard it explained like that. Maybe because I'm just so much on the side of victims and co-homicide survivors. So I automatically look at this person who they say is the offender, and I'm just looking at them like, you're guilty, you know what I mean, you're horrible, and you should be put away. But I never heard it explained like that, which is excellent. So one more question, and you don't have to answer this if you don't want to. How does it feel defending someone that and they told you that they did something like so horrible? Does that make your job even harder? Or again, you're going to make sure that even if they are found guilty, that the constitutional right is that I'm going to fight for your rights.
Yeah, so let's take a step back. As a former prosecutor, I would say that a high majority of people who are charged with crimes are typically guilty of those crimes. As a defense attorney, I would say, and my experience has been that there are cases in which the government gets it wrong.
Mm.
I defend people, whether they tell me they committed the crime or they say that they didn't commit the crime. I treat the case the same way, except there is a conversation with the client. This is the evidence against you. We can seek a plea bargain. We can try to we can try to get a deal. This is the benefit, the pros and cons of that approach. If they acknowledge that they committed the crime, then that conversation is easier and typically leads to a plea. In a federal system, 90-something% of the people who are indicted or have an information filed against them plead guilty. In the state system, that percentage is less, but a large majority of people charged with crimes in the state system also plead guilty. There are very few criminal cases that end or result in a trial. Typically, it's ones where the stakes are high, such as in murders, or manslaughters. Or there's a defense like a justifiable homicide, because those cases are eminently triable because the facts could work either way. But to answer your question, I have no difficulty representing someone charged with a crime because it's my constitutional obligation as a lawyer to stand between the government and them and make the government meet its constitutional obligations and prove the case against my client. Now, that being said, as I mentioned, when I was a prosecutor in the DA's office in Philly, I prosecuted people who were accused of sexually assaulting children. So I make the choice not to represent people who are charged with that crime. They have an absolute right to constitutional defense. They just don't have an absolute right to me defending them. So I make sure they get referred to someone else. But otherwise, I feel that I have the duty and an ethical obligation, if I take a client on, to make sure I do everything in my power to make the government prove its case, or dissuade the government from pursuing the case by demonstrating to them either that the client didn't have the mens rea or the mental state that they think the client had, or demonstrating to the government the case is not as easy as they think. And if they try the case, there's a strong possibility that they lose. And sometimes that backs prosecutors off.
Well, I want to thank you so much for breaking everything down for us today. Very hard conversation, but I wanted to bring clarity to anyone watching this show. Thank you so much for joining me today, Kevin.
Melany, it was my pleasure, and I hope that this was informative to your listeners. And thank you for having me on.
You're welcome. Thank you so much for joining me today. Please understand our condolences to anyone who has lost a loved one to any type of homicide or murder. We wanted to bring clarity and understanding to the law in PA. Peace and love.